All right, Jeff Lax is a law professor. Professor, let me ask you a question. It's interesting here. There are no standard prescription amounts, so on and so forth. This nurse is talking about overrides, and emergency situations can be very subjective. Does this actually help the defense, or was this a good prosecution witness in your mind?
Yeah, I absolutely think it helps the defense. As we've seen throughout this trial, and as you mentioned, to open the segment, that there is no standard. In fact, Jose Baez did a phenomenal job getting multiple medical professionals, including doctors, to admit that they wouldn't want to say anything about the treatment without knowing the specific circumstances in each case, treating the patient directly. So, yeah, that's very helpful to the defense because if there is no standard, then there's nothing to go past, officially in terms of the whatever the policy was. So yeah, very helpful to the defense.
Yeah, well, let's listen to a little bit more of the direct examination with respect to this override, which is giving the nurses the opportunity essentially to countermand, if you will, or to, in emergency circumstances, do something that necessarily wasn't prescribed by the doctor. Very interesting that the prosecution is calling this witness. Let's listen to a little bit more. Professor, let's get back to the same point that I kind of expand a little bit about what you were saying before. He's even talking about the subjective nature of how nurses do certain things with regard to palliative care, and everyone kind of does it a little bit different. Does that not lend a little more subjectivity, again, to this whole process about how to medicate or how to go about handling a patient under these circumstances? And do you think the defense is going to exploit that in their continued cross-examination?
For sure. I think that's been the theme of the entire defense, which is this is subjective. You need to do it on a case by case basis. Like I said earlier, all the doctors have basically testified that we would want to know more about each specific circumstance to know what the proper treatment was. I thought there was a huge missed opportunity in that line of questioning by the prosecution, which shocked me because here you have the witness, this nurse, saying that I've never prescribed doses. I never filled doses that high before of this medication. And the prosecution just let it go, moved on to the darkening of the room, which I thought was bizarre. The prosecution should be focused, in my opinion, on these levels of doses have never been given before, and I never gave it before. And I thought they missed it there. Maybe they'll come back to it. But certainly with that witness in that situation, I thought they missed a big follow-up.
Yeah, it talked to me, Professor, about when you have to prove a case beyond a reasonable doubt, and you have to also talk about causation and intervening causes. When there is no standard, I mean, I find this to be unbelievable. It's just a regular layperson, who may have a family member, God forbid, that's in this kind of distress, to know that there are no real guidelines. How much does that affect the prosecution's case in terms of the fact that there's no bright line and that it's so subjective when they have to prove kind of like an intention that this was done for the purpose of killing a person as opposed to palliative care?
Yeah, for sure. I mean, that's what reasonable doubt is. When you say it's a fine line, that is reasonable doubt. If you're not sure, remember the mental state of mind of the doctor here, what we call the mens rea in criminal law, is what really matters. Did Dr. Husel want to kill these patients? Was that part of what he was doing? Was he intending to, mercy kill the patients? And there's so much evidence against that. For example, and I thought another great job by the defense has been showing that the doctor administered plenty of life-saving treatments to the same patients. So it doesn't even
Mm.
make sense that why would he administer other types of treatments, not related to the fentanyl? And then why would he save them and then kill them with fentanyl? So they've done a great job of defense, but you're right. You're 100% right. When you hear everyone saying, wow, this is a close call, to me, that sounds like reasonable doubt. Yeah.
Yeah, and Professor, you make a great point too. That he's also doing life-saving measures with regard to that patient, which would be counterintuitive to the government's argument. I can't wait to come back and talk to you about the concept of jury nullification in a case like this, but we will have to take a quick break and talk about that on the other end. Please stay with us.
Okay. But I think never is too strong of a word, so I would take that back.
Professor, let's add a wrinkle to this. That was cross-examination of the state's medical expert in the case, where essentially they're talking about the families consenting to palliative care. I kind of want your opinion about, again, something that I think may be beneficial to the defense in the case. And in the end analysis, talk to us about jury nullification in matters like this, how these these kind of wobbly facts like, well, it's subjective and the nurse can override and the family has a decision-making process and all this. Talk to us a little bit about your idea of jury nullification.
Well, jury nullification, as you know, is not part of the criminal procedure in any state, but it's certainly something that juries do make uses of when they think something is unfair. And you're making a great point here when you combine really what might be viewed as compassionate care, especially with consent and discussion with the families, with something that technically violates the law. There have been a number of, high-profile examples in modern times. The O.J. Simpson verdict, I think, likely was a result of jury nullification. That I think most people watching the trial believed that O.J. was guilty, and then in fact he was found liable in a civil lawsuit. But the jury obviously acquitted O.J., and I think that was for other reasons, other things that bothered them. So juries you can't penalize a jury for coming to a verdict that is technically not under the law. But you make a great point. That could be this situation here where a doctor, is trying to do something that he feels is right, that the law may say is wrong. So it's a tough call.
Mm-hmm. Yeah, and especially if you got that fine line thing going on, they may have a difficulty of bridging whether there's even guilt beyond the reasonable doubt. But then you add that piece of jury, which I can tell you personally is a real thing that goes on in a jury room, especially in a case like this. So, you can always tell, or should be able to tell, when a lawyer feels that their witness has been hurt by how they go about their redirect examination. Redirect examination shouldn't be something where you just get another opportunity just to throw out your case. So you can kind of tell where they're going if they're concerned that the jury heard something. Let's listen to a little bit of the state's redirect examination with regard to this very issue.
Let's go sidebar.
All right, Professor, let's go back to the same point that I think we're going to be making over and over again when we see some of these clips. Does this witness help the prosecution or the defense? Because the bottom line is if these people are administering these drugs, they must not have thought when they were doing it that they were doing anything that was inappropriate. It's not like they were under the Svengali control of a physician and that they didn't have a right to go somewhere in their chain of command if they felt something was inappropriate. What are your thoughts about how the jury's viewing this witness?
Yeah, I think you're making the point. The prosecution is in a little bit of a mess, in my opinion, to be totally honest with you. I mean, even within that small sample that we just heard, where the prosecution is trying to make the case, that I guess, I'm not even 100% sure what their point was because it was a little all over the place, but I think they were trying to make the point that the medication morphine was given very often. And first of all, two bad things happened for the prosecution there. One, she said, no, that was not the case. And number two, the prosecution asked her to read, did the patient's pain subside after this administration, after that? And the answer was no. And so all you do is feel bad for, first of all, obviously the dying patient who was suffering, but you also feel bad for the nurse on the stand. Because what a tough predicament, this nurse is in, who got suspended, who was on administrative leave, and there were other nurses in the same position you heard earlier today. So I don't know that the prosecution is accomplishing what they want to with this type of question line, except to make people feel sorry for the victim, for the doctor, and for the nurse who were involved.
You took my next question, like right there in the last answer, and I'll amplify. I can't help but think that the jury's not going to feel bad for the family and the patient as well that these doctors and nurses are confronting. And it gets back to my original point about when you add all of these emotional things up, as well as I do, Professor, that juries put themselves in the shoes of the people that they're listening to testify. Do you think there could be at least one juror, because that's all it takes, that sits there and says, this would be the kind of treatment I would want my family member to get if they were in pain and the pain wasn't being managed? I want them to receive more medication. I can tell you personally, unfortunately, from my firsthand experience, that's the way I was with my mother.
Yeah, I don't know what to say. I agree with you. We're all human beings. This is not a legal question, but I'm talking to you as a human being to another human being. If we're in the jury room and we feel the same way, and we think that there might have been a technical violation of the law, although I'm not personally convinced there even was in this case. Yeah, we're all human beings. And yes, jury nullification is a real thing, and the jurors can do what they see fit, and they're beyond reproach, as we both know.
And let's take a listen to Jose Baez, the defense attorney, cross-examining on this very point, which at a minimum, as myself and the professor are talking about, is speaking directly to the emotional feelings of the jurors about what they're seeing with this testimony. Let's take a listen to the cross.
Correct.
Doctor, I mean, again, the cross-examination by the defense attorney of what you know as a prosecutor is going to be a favorable witness for the defense because she got called to the carpet for this particular situation, and I'm sure she wants to defend her actions, but how impactful is it to the jury that they were going to be saying goodbye to the family for the last time because that's the shape that she was in and that she was in pain and suffering? I mean, I think I know what your answer is going to be, but again, why is this witness on the stand?
The answer is in the witness's face. I mean, you see her on the verge of tears, and she's not on the verge of tears for her own family member. She's not on the verge of tears for her own situation. She was on the verge of tears recalling what it was like for that poor victim who medication did not help the victim. She testified to the fact that, you gave this medication, it didn't work. You gave that medication, it didn't work. Patient was still in pain. That's why she was tearing up and almost crying. And like you're saying, that's a tough thing for the prosecution, and certainly something that if I'm the defense, I feel good about the fact that it's a good argument that the doctor was doing the compassionate thing.
Yeah, interesting. I actually handled as a prosecutor a mass murderer who had, as a nurse, poisoned a lot of people end of life, but it was well before their end of life and was convicted. But I see this case differently, and I'm curious if you have any thoughts about why do you think the prosecutor charged 25 counts, then wound up dropping 11 counts? Like, to me, as a former prosecutor that led an agency, that to me speaks of sloppiness. And secondly, is there a political motive in your mind as to why prosecutors do these cases because they think they're going to make a point or they want to have deterrence? What is your understanding as to why this case was even brought in the first place and why 11 counts eventually or 14 counts were dropped?
That's a lot to unpack in those questions. Let me tackle the point about the 11 cases that were dropped. So of course this jury is not going to hear that. This jury is not going to be provided with the information about the cases that weren't brought, and I happen to disagree with that. I think that should have been allowed into evidence, not because it shows the doctor handled certain cases correctly and some incorrectly, but because it really shows that this is the fine line we've been talking about, and that should be allowed as evidence that in some cases it seems more okay to some people, but really it's a fine line and it's a subjective, we've been talking about this whole time, is this subjective? And that to me should be admissible evidence to show how subjective this is. Why this case was brought in the first place? Listen, I agree with you. But we now have the benefit though of 13 or whatever it is, 12, 13 days of trial to see what I think you and I seem to be agreeing on is a weak case by the prosecution and a sympathetic one for the doctor. And all these other, the nurses aren't on trial here, but they've been disciplined. So they've also suffered ramifications for the deaths of these patients. And it's been tough on everybody. And I think it's going to take a very emotional toll on the jury. This is going to be, like you said, this is going to be a very emotional jury if this goes to, if this actually does go to the jury. Which at this point, would I be shocked if it didn't? Mm-hmm. I actually wouldn't. I wouldn't be shocked.
Professor, I would love to get into it, and we will somewhere during this program, about the tactical decision whether it should be admitted about the cases that were dropped or not. I think it's a really interesting subject matter. I want to hear from an evidentiary point of view your thoughts on whether it benefits one side or the other. But we're going to have to take a quick break, but don't go anywhere, because on the other side, as we told you, Gabby Petito's family has sued Brian Laundrie's family in a civil action, and it's very interesting. We're going to talk more about that when we come back from the break. Please stay with us.
So, we are right outside Capitol Reef right now in a free dispersed camp spot, and we've been lucky so far at all the places we've stayed, but I'd say this is one of the best so far. Since we left New York, I've only set up my hammock once, and now we're all the way in Utah, and luckily enough, I was able to set up my hammock in one of these trees.
And we're kind of like in the desert.
Maybe a few trees.
In a obviously very, very tragic case, Ms. Petito was found dead in Wyoming, and then the hunt for Brian Laundrie went. And obviously, he was found in a swamp, his body decomposed, but also with a note indicating there, among other things, that he is the person that actually killed Ms. Petito. Now, the family of Gabby Petito's filed a lawsuit against Brian Laundrie's parents, indicating that the parents knew and that the defendant had confessed to them that he had murdered them. And the suit even goes on to saying that the parents were keeping his whereabouts a secret. As you know, the Laundries had a family attorney, Steve Bertolino, who was very out there in the public, indicating that his clients had a right to remain silent and not assist in the investigation. He actually gave a statement after this lawsuit was filed that reads as follows. As I have maintained over the last several months, the Laundries have not publicly commented at my direction, which is their right under the law. Assuming everything the Petitos allege in their lawsuit is true, which we deny, the lawsuit does not change the fact that the Laundries had no obligation to speak to law enforcement or to any third party, including the Petito family. This fundamental legal principle renders the Petitos' claims to be baseless under the law. So, Professor, I for one, even as a former prosecutor, now criminal defense attorney, was a little taken back when this case was going on. I felt personally, having handled investigations like this, that by going out there and saying that the family had knowledge and the family was covering up and law enforcement officers were calling people persons of interest was inartful, because when you do that, you cause people to, I'm going to give you a legal principle, Professor. I'm sure you talk to your students about it all the time. We call it pucker up. Is going to make them go to a lawyer, and any defense lawyer and any prosecutor knows that is going to tell them you're being alleged to be a participant or an accessory after the fact. Assert your right to remain silent. So my first question to you is, what were your feelings while that was going on? And do you agree with the statement that the Laundrie family's attorney gave with respect to their right to remain silent, and that this is not a valid claim for a civil lawsuit?
Yeah, there are two sides to this. You have the criminal side. Obviously, you can't obstruct an investigation. So to the extent that something they did obstructed the whereabouts of Gabby Petito, that's a whole different matter. And it could be. I mean, I don't know what they knew. But yeah, you're right. Of course, you would instruct somebody in that situation to remain silent. And in terms of the civil lawsuit, this is, I read the complaint. It's really probably one of the worst legal documents I've ever seen. There's not even a cause of action, a legal cause of action, even attempted to be asserted in the complaint. I've never seen a complaint like that. It doesn't even, it seems like it might be arguing some type of intentional infliction of emotional distress, but it doesn't even name that as a claim, as a cause of action, because I think they know it's not really a claim, and they're just trying to find some way. Then they call it negligence generally, but not really. They just check off the box on what used to be those bluebacks where you check off negligence, but they don't even cite what kind of negligence claim it might be. This is not a legitimate lawsuit. It's going to be thrown out, in my opinion, very quickly if you have a judge who, has handled any amount of civil tort or negligence cases, because there isn't even a cause of action stated in the complaint, not even remotely.
Yeah, talk to us, Professor, and I agree with you completely about what a cause of action means. I mean, I think a lot of people think that you can, if you're aggrieved or you feel somebody's done something wrong, that you could just throw it on a piece of paper, file a lawsuit, and that you'll have a lawsuit. And what lawyers were likely to do in answering this quote unquote lawsuit, because it does not establish a claim under the law.
Yeah, you can't just, I always tell my students, if you get very upset, if somebody says something to you that makes you very upset, can you sue them? And some of them actually not sure. Well, it depends. How upset am I? And I said, well, you're thinking about the wrong issue here. The issue is, does it violate the law? Is there a cause of action to your question? And in order to state a cause of action, to state a claim under the law, there has to be a recognized area of the law that has been violated. So, for example, the best example is what they used here, because they cited generally to the word negligence. Well, in order to be liable for negligence, you have to have owed a duty of care to somebody. So then you have to ask yourself, well, what duty of care did the parents of Gabby Petito, were they owed by the Laundries? And the answer is none. They did not owe. They weren't landlord-tenant. A landlord owes duties to a tenant. That's a classic example, property to a property lessee. or a property renter. But Gabby Petito's parents in this case were not owed any duty. There was no actual legal relationship between the Petitos and the Laundries. And so there couldn't be any violation of the law. I think this lawyer knows that. I hope the Petitos know that. But I feel bad because it's like you said, it's a very sad situation. It's a horrible situation. You almost wish that the Petitos have a claim, but the reality is they really don't.
Yeah, if you ask me, there's also a shot and a very interesting aspect of this case that if it survives a motion to dismiss in the beginning of the case, then the discovery process begins, which could compel, certainly they would want to compel the Laundries to testify. So you got all sorts of Fifth Amendment issues with regard to that. We'll have to address that at another point in time. Billy Ray Turner's another case. This is a cold case. The victim was shot in 2010. The body was found 9 days later, but the case went cold, and it wasn't until 7 years later when a gun was recovered in a river that the police made an arrest. Shortly afterwards, Wright's ex-wife was also arrested in connection with this case. He's pled guilty, will probably be providing evidence to the state. We're dealing with infidelity. We're dealing with insurance policies. So, Professor, what do you think about the makeup of this case so far? What's your assessment?
Boy, it's a crazy story. The person who shot Lorenzen Wright was, I believe, the family's deacon. So it's such a crazy story. And as you know, the ex-wife is already incarcerated. I believe she was sentenced to double-digit years in prison for her involvement in this situation. So the defendant has a lot going against him just to start, because will the ex-wife testify? That's a big question. Can the prosecution offer her something, get her off of her sentence, possibly? But there's a whole lot of evidence already out there. And then you have the kids of the family who are now, I believe, adults, and they might possibly testify. There's a lot of evidence out there. We'll find out in the coming days and weeks.
Yeah, so you expect that the government may call her as a witness, and if so, you anticipate any level of attack by the defense on her testimony?
For sure, they can certainly attack her credibility. You can certainly impeach her, but the fact that she was already convicted related to conspiring with this defendant to murder her ex-husband, and so that's not good. She's clearly a prime witness, and yeah, you can do what you can as a defense, but it's going to be a rough go for this defendant, in my opinion. It's a tough case for the defense.
And Professor, it was a cold case for a while. Can you tell our audience a little bit about some of the difficulties that prosecutors have to go through with a case that's aged that old? You always look at a fresh case as opposed to an older case. Do you anticipate any problems based on the age of the case?
For sure. I mean, if you're the jury and you're hearing the story, you want to know, why did this take so long, and why didn't they have the evidence in the proper timeline? But I think part of the story here is how the cover story was covered up. The ex-wife and the deacon defendant went to great lengths to cover up the story. And I think that's one of the reasons why it went cold for so long, was the efforts they went to make it seem like something totally different than what it was. And I think that in this case, you're right. Usually, cold case goes against the prosecution, but in this case, I think it might be reversed, because I think it went cold, and we'll hear more obviously as the trial moves on. But I think it went cold because of their cover-up.
Yeah, and I think that's a very good point. And that cover-up will be used by the prosecutors to show consciousness of guilt and other things, so to their advantage. Okay, Professor, really appreciate it. We're going to take a quick break here. Hopefully, when the Husel case comes back, we'll have more of that interesting testimony. Stay with us.